Good morning, everyone. Today we have Dr. Prateek Deol, Associate Professor. He is currently heading Center for Intellectual Property Right, SRMUH. And today we are going to discuss upon the judgment of Association for Democratic Reforms versus Election Commission of India and another. So we are having particularly this discussion in light of celebration of Constitutional Week or the Constitution Day that is being celebrated on 26th of January 2025 this year, and it is celebrated since 1950. So in regard of this, I welcome you, sir, and would like to ask you something regarding this particular judgment, that the petitioners have raised a very serious concern or question or allegation that the source code of the firmware of the EVM machines can be altered by the political parties or to reflect in a particular manner upon to favor a particular political party, right? Now, I'd like to ask, how did the court utilize the technical concept of burnt memory? Right. So, and the agonistic nature of the control unit to legally and technically dismantle the argument that the machines can be altered or tutored in specific manner.
Thank you so much, Mr. Vishesh, for inviting me at the outset to this particular podcast. And it is a privilege for any faculty of law to discuss upon the landmark judgments that have been delivered by the Supreme Court of India on different aspects of democracy. Sure. So all those who are listening to us and viewing us, it's a special request that if you are a student of law and even if you are a citizen of India, you should read this particular judgment. It is one of the most beautiful judgments in the aspect that every detail of the mechanism in which the voting has to be done has been discussed by the Supreme Court of India in length and breadth. I would like to inform our viewers at the outset that this particular judgment is a judgment coming from the apex court of the country, and it was a division bench judgment. Essentially, Justice Sanjeev Khanna and Justice Dipankar Datta have written the judgment in the instant case, and the case is a summation of total number of 47 pages, in which the first part of the judgment is delivered by Justice Sanjeev Khanna and the second part of the judgment is delivered by Dipankar Datta. So paragraph 1 to 77 of the judgment is dealt by Justice Sanjeev Khanna, and the later part of paragraph 1 to 38 is done by Justice Dipankar Datta. So when we refer to paragraph 19 of the judgment of Justice Sanjeev Khanna, therein he has mentioned that there are two agencies which are responsible for the manufacturing of the EVM, and those two organizations are BHEL, which is Bharat Electronics Limited, which is under the control of Ministry of Defence of Government of India, and the second unit is called as the Electronic Corporation of India Limited, which is under the control of the Department of Atomic Energy. Yeah. So at the outset, it is to understand that it is not possible for the Election Commission of India to do anything with respect to the manufacturing of this particular appliance at the outset. However, there is a very technical concept which is with respect to this particular appliance, in which there are three essential components of the entire mechanism, which we in our ordinary day-to-day understanding, we use the term EVM. Now, the EVM essentially consists of three components. The first one is called as the controlling unit or the control unit in simple words. Now, this control unit is under the control of the presiding officer of the polling station, or it is looked after by the polling agents, which are there under the control of the polling officers. The second aspect is called as the ballot unit, on which every citizen of this country goes and votes. Yeah. Now, when one goes and votes, the EVM has three specific components in it. The three specific components of the EVM are as follows. One is the serial number, second is the name of the candidate, third is the symbol of that political party or the candidate which they are using in the instant election. they are pasted onto the ballot unit. And as soon as the voter decides to vote, there is a blue button onto the ballot unit which one will press, and to the left of the button you will see a red light flashing upon it. There are total 16 options which exists in the EVM. The 16th option is that of none of the above. And the third component is, which is the most critical part, is called as the verifiable voter paper audit trail, in short VVPAT. Now, if a citizen is voting, so there are two mechanisms in which it operates. The first one is that as soon as I have voted, I will be able to see the red light next to the button which I have pressed. And to adjacent of the ballot unit exists this VVPAT unit, in which the voter is able to see that how the vote has been casted upon. So, as a voter, I will be able to see for myself that there is serial number, there is name of the candidate, and there is the symbol of the political party or the candidate which they are using in the instant election. None of the three units are interconnected to each other, point number one. Point number two, none of the three units are connected to the internet, they operate on batteries. So, there is no way that one can tamper with the EVM. If we look into the judgment, we will find that there is a mechanism which is used in the judgment which is called as unauthorized access detection mechanism, which is provided within the particular machine. So, if anybody tries to tamper around with that particular machine, automatically the data of it will not be accessible, it will be, it will not be able to, it will not be used at all. So, the fear that there is a chance of tampering with the microchip is not possible. The way in which it is framed or manufactured is that if there is anybody who is trying to do an unauthorized access, then the detection mechanism will activate, and automatically the data inside of it is not accessible. Now, what happens is that if one is to access the data, then it is crucial that every machine has its own unique code which one has to enter in order to access the data. And this is not available with everyone. This is available only to the district officers, election officers, which are administering the entire process under their leadership. So, it is not possible for any person to maneuver or maladminister the machine. The way in which it is been scientifically constructed is that it is having a microware in which it works, so that there is an electronic recording of the vote which the candidate has done, and therefore it is not possible for a person to physically tamper with the machine, and the entire construct of the appliance is in a way that it promotes the fairness and transparency in the election. So, this fear of malfunctioning is ill-founded in that particular way. Thank you.
Yes, sir. So, you mentioned this VVPAT machine. So, this VVPAT machine or the glass window of this VVPAT is tinted, right, rather than being transparent. So, this is has been stated by the petitioner that this is a clear violation of Rule 49M of the described machinery, and thereby violating the voters' right of fundamental right to under Article 19(1). So, so how did the court balance the voters' right to know and while maintaining the secrecy that is mandated by the Election Commission of India regarding this, and regarding that 7-second window? So, how did they balance with it?
So, there are essentially two questions in this particular one question. The first part of the question is that why the window of the VVPAT is not transparent. It should be transparent, and instead of that it is tinted. That is the prime concern, to which the Supreme Court of India has replied categorically, stating that the reason why we have done it is so that, one, it maintains secrecy. Second, that the vote which I have casted upon should not be visible to anyone else, because it can be a threat to the elector who has come to vote. Third, which is highlighted by the Supreme Court, is that when the electronic VVPAT is visible to the voter, they are able to see the three things again. The first thing which they are able to see is the serial number, the name of the candidate, and the symbol of the political party or the candidate for which they have voted. It is visible to them for 7 seconds. Thereafter, automatically, the vote which has been casted upon by the voter is cut and is located inside the VVPAT trail. So it is systematically, step by step, stored within the VVPAT trail. Now, one query which was raised by the petitioners in the instant case is that 7 seconds is not a sufficient time. So I would like to inform our viewers that EVMs is not something which is of recent origin. It has been into vogue since 1980s, and it was first time used in the year 1982 in the Kerala by-elections. This history has also been dealt with by the court in the instant judgment, and since then, so we can say for almost 45 years, the EVMs have now been in vogue, and they are strengthening the entire election system of the Union of India. So, and strikingly, one very, very unique feature which has been highlighted is that till date, there has not been any instance in which the discrepancy has been reported with respect to the what has been voted upon and what has come to the electoral officers and in the form of a VVPAT trail. So they have not been able to find any defect. One case which was reported was also duly taken care of as per the EVM manual by the presiding polling officer of that particular poll, and they have taken care of. The question with respect to the elections was also raised by the parliamentary committee before the parliament. So the Election Commission of India has replied to that particular notice of the parliamentary committee, in which they have mentioned about the level of accuracy which the EVM is exercising in respect of the casting of vote. So the fear that, one, it is not transparent is ill-founded, and therefore the visibility is less is ill-founded, and the Supreme Court of India has relied upon the efficacy level of the Election Commission of India's usage of EVMs, that since there is nothing on record to show that there has been a temper or there has been a malfunctioning of the EVMs, therefore the credibility of the apparatus is beyond doubt. And it is not manufactured by a local company. It is manufactured by two units which are exclusively the government's own PSUs, which are distinct with each other in their operation and functionality. So the fear of the misuse of the vote is not so strongly founded and was rejected by the Supreme Court in its observation. Thank you.
Okay. Sir, the primary relief that the petitioner sought was that of counting of 100% votes manually. However, Supreme Court rejected and stick to the 5% counting of votes.
Right.
So, sir, in what manner have they justified of manual counting? As in, how they have justified that there can be human errors?
Yes.
That has been justified by the Supreme Court. So, what were the reasons on which this has been founded?
So, if we refer to the Supreme Court's verdict, so we will see that from paragraph 30 onwards, you will see that they have been able to discuss the functionality of VVPAT in detail. Now, what happens is, when we are looking at the functionality of the VVPAT, we would see that 100% verification of VVPAT would come only when there is a defect in the functioning of the apparatus. Besides that, it is wonderful judgment. I would really request everyone to please read that the way in which the Election Commission of India has ensured the insight, the nitty-gritties which they are following with respect to the guaranteeing of free and fair elections is that in the N. Chandrababu Naidu case, the Supreme Court of India came out with the instruction that you will do the 5% verification of your VVPATs, because that is the exact vote which is to be counted upon. Now, this, in order to ensure the compliance to this particular instruction, what happens is that one EVM of every polling station is randomly selected by the electoral officers for scrutinizing the way in which they are functioning. I would like to go in elaboration before their use, how are they checked. So once the EVM is manufactured, it is handed over to the Election Commission of India, and then there is a detailed process which they follow. Now what happens is that the Election Commission of India has to do FLC, which is called as first level check. Now this first level check is again done for all the 100% of the EVMs, and it is done for 6 times, not once, not twice, not thrice. They are doing it 6 times, 100% check of all the EVMs. Now when this is done, it is not done secretly. It is done in the presence of the electoral officers. It is also done in the presence of the political parties or the representatives of the political parties interested, so that there can be a complete transparency. It doesn't stop there. They have to further do it under CCTV surveillance. So this doesn't happen in an opaque room wherein everyone and anyone can tamper. Let's assume that there is a convolution of everyone. Then also it is ruled out because there is a videography which exists. After the first level check is done, the second level check again happens. In this, what happens is that 5% of the machines are used in order to cast the vote. But this is not done for the public. Now what they do is, the 5% is split like this. The first 1% of the EVMs will have 1200 votes. The next 2% of the EVMs will have 1000 votes. The next 2% of the EVMs will have 500 votes. So the 5% of the EVMs which are randomly selected is further reselected for second level scrutiny, in which these votes are checked. Even when this is happening, the same authorities are again present. The electoral officers along with the political parties are present under CCTV so as to check the veracity of the machine which is functioning. After that, 10% of the machines are taken again with the permission of electoral officers and with the approval of the political parties and their representatives for demonstration purposes. This is third level. So when they are taken for demonstration, there again they are tested, and thereafter the persons are the normal electoral people. The electorate is entitled to vote. It has been submitted by the Election Commission of India to the Supreme Court of India, stating that 50% of the electoral ballots are under CCTV surveillance. It was noted by the Supreme Court that the 2024 general elections have an estimated value of rupees 1 lakh crores. The Supreme Court of India has talked about the geographical dimensions in which the country has to vote. So the court observed, it's a beautiful judgment, that the EVMs are carried on the back of horses to the Himalayas, while they are also taken on foot or on cycles to the forest regions of Sundarban. It is not just the plain areas in which the voting happens. And there is a huge population. The more than 10 lakh polling stations are created by the Election Commission of India to conduct the elections. So we can understand the gargantuan scale on which the exercise of Election Commission of India happens. And there are very few democracies in the world who are conducting elections to this geographical terrain and this size of the population. Supreme Court of India in the instant case has observed very categorically with respect to the state of West Bengal, wherein they observed that the population of the state of West Bengal is more than the population of few of the countries of Europe. So this is the kind of logistical challenge which the Election Commission of India is fulfilling.
Yeah.
So when we see the in-depth nitty-gritties to which the Election Commission of India is handling in terms of elections, we will be forced to appreciate the efforts which they are taking in order to ensure free and fair elections. So this particular fact that everything has to be paper tallied, there is no proof that there has been a damage or a mishandling of the EVM. Second, with respect to the only 5% rule, which the Supreme Court has given an incremental suggestion to that the Election Commission of India is only taking one EVM per polling station for the purpose of random scrutiny. The Supreme Court of India has gone farther. Supreme Court of India has observed in the instant case that the Election Commission of India has the capacity to check 5 EVMs randomly per polling station. So in order to increase the system of accountability and transparency, they have given this suggestion to the Election Commission of India that you should try and comply with it also. Yeah. Besides that, the Supreme Court of India has taken up a very wonderful suggestion, and I am not sure how many democracies in the world are following this, that there should be a barcoding of what we have voted as a voter in the VVPAT, so that it becomes impossible for any person to tamper with what has been voted once it is barcoded. These are incremental suggestions which have been given by the Supreme Court in order to ensure and to strengthen the process of free and fair elections. Besides that, the Supreme Court of India has read the particular right of 5% in two facets. One of the facets is that everybody has a right to cast the vote. So how is that guaranteed? Rule 17A of the Representative of People's Act has a format in which there is a serial number, name of the elector, the document which he or she shows as a matter of proof that she is the voter, that signature of the candidate, and then the remarks of the presiding officers. Now, when I am entering as a voter, I will have to physically fill that particular data, and then I am entering into the same. And mind it, 50% of the polling stations are under CCTV surveillance, the record of which is kept for 45 days after the election results are declared, and anyone, not just the elected candidate, even the voter has the right to file a case under Section 80 of the Representation of People's Act to check the veracity of the vote which he or she has casted. So the Supreme Court of India has observed in the instant case that assuming that there is a tampering of what has been done, the voter is not left remediless. They have a remedy under Section 80, and it is not just the contestant who has the remedy. An ordinary voter also has the remedy. So the Election Commission of India has ensured full and fair transparency to the way in which they are conducting the elections. So there is no need of having 100% verification of VVPATs. And Election Commission of India has officially said it to the Supreme Court of India that we are facing logistics and human resource challenges in order to conduct the elections of this size, which is not conducted by any democracy in the world. That is what Supreme Court has considered. Given the circumstances, still the Supreme Court of India has given incremental suggestions to the Election Commission of India to ensure free and fair elections in India. Thank you.
Yes. So, sir, in his concurring opinion, Justice Dipankar Datta has discussed regarding the maintainability of writ petition under Article 32. So, in this regard, sir, he has made a sharp distinction between the real threat and mere suspicion. So, sir, based on this, according to his reasoning, why is suspicion alone not sufficient to invoke the extraordinary jurisdiction of Supreme Court as a writ petition?
If we refer from paragraph 19 onwards of the judgment of Justice Dipankar Datta, we would be able to find this particular question. Now, what happens is that this was pleaded that there is a chance of violation of my rights. So, the Supreme Court of India has observed in the instant case that this fear has to be not a suspicion or a presumption. It cannot be ill-founded. And therefore, it is essential that the fear which they are alleging should be having some basis. And the court of the Supreme Court of India has used the doctrine of res judicata in this particular scenario. However, the res judicata does not apply to writ jurisdictions. Still, the Supreme Court of India has used it with a caveat. If there is a danger to the public interest, then in that particular circumstance, the Supreme Court of India will relax the doctrine of res judicata and will admit the new applications if there is any serious allegation found with respect to the violation of free and fair elections. One. Point number two, there were reports which were referred of private organizations in the particular case. So, the Supreme Court of India took and the Justice Dipankar Datta specifically made reference to the reports which were highlighted, and the reports are contradictory. The reports themselves are contradictory, and the reports states that it is not possible to temper. However, it cannot be said that it is not possible to temper. So, the Supreme Court of India has said that what kind of reports are these, and besides, very important factor, that these reports are not of the governmental institutions. They are private reports which were used before the Supreme Court as a matter of reference. These were private organizations. The Supreme Court of India therefore did not rely upon what was submitted by the petitioners as one of the grounds on which they can say that doctrine of res judicata need not be invoked. They did not accept that particular argument, and the reports themselves were representing an ironical statement. Therefore, this was rejected by the court, saying that there is no proof to show that there is a violation of your rights of having a free and fair election. So, therefore, the petitions will not stand ground, and you will have to prove that there is something to be suspicious about. So, there is nothing to be suspicious about, and Justice Dipankar Datta has gone back, and he reflects in his judgment. He says, this makes me to think that was it not the case that when people were using the ballots, they also had no access to what they have submitted inside the ballots, and how they were guaranteed of any legal protection, that what they have casted upon is actually counted upon. So, the petitioners argued upon two facets. Sorry, I missed it. The petitioners argued upon two facets. One is my right to cast the vote, and to know that my vote has gone to the one to whom I have casted. So, the Justice Dipankar Datta says that was this facility available to the previous voters? This was never available to the previous voters. However, in the instant way in which the Union of India is conducting elections, general elections, state assembly elections, and local constitutional authorities elections, there is transparency in which there is 3 stages in which I am able to see my voting pattern. One is the light when I have voted upon the ballot unit. Second is the VVPAT, wherein I see the electronic receipt kind of a thing of what I have voted upon. And third is the loud sound which comes in the form of a beep, which is a further confirmation that I have done my voting part. And it is not done in a fraction of a second. The Supreme Court of India has dealt the matter in so much detail. It was reported that it has been recorded by the Supreme Court that it takes 15 seconds for any person to conclude the process of voting. So, in a minute, maximum of 4 votes can be counted upon. So, not more than that is possible any which ways, which rules out the largest chances of any sort of tampering. And if we refer to paragraph 33 of the judgment of Justice Sanjeev Khanna, he has dealt in point wise what are the advantages of using the EVMs. If I may to say, one, it runs on battery or power packs and does not require any external power supply. Second, voting is done by a pressing button, thereby negating a scenario of invalid vote. Third, it does not permit 4 votes more than a minute, and it deters and disincentivizes booth capturing. It ensures quick, error-free and mischief-free counting of votes, and voter is instantly able to verify, this is very critical, to verify the recording of their vote through the beep sound. How else can it be guaranteed to a voter? And what more in detail is required for a voter to understand that what you have voted for has gone to the one you have voted for?
Yes.
So not only I have exercised my right to vote, I have full information, full access to the information that the person to whom I have voted is the person to whom the vote has gone. So therefore, there is no need of worrying that there is any mala fide which is happening in the functionality of the elections, and Election Commission of India is not taking proper care of it. So therefore, the court rejected this plea and concluded in this format. Thank you.
Yes. So, sir, this issue of EVM integrity has been raised multiple times before the Supreme Court of India. So, Justice Datta invoked the doctrine of res judicata, as you stated. But even though these were the public interest litigations, how did he justify applying the public interest litigation in this case? And what public policy rationale did he use to argue upon the debate of EVM, which must eventually come to an end?
Under the paragraph 28 of the judgment, the Justice Dipankar Datta has categorically mentioned, and he writes, to maintain these writ petitions, it ought to have been shown that there exists a tangible threat of infringement. However, that also has not been substantiated. So the plea of the petitioners that there is a chance of tempering, no temperament has been reported or recorded or exists, but there is a chance of temperament which can happen. So the Supreme Court of India has observed that there exists no tangible threat of infringement and they have not even been substantiated. So these are mere allegations. Justice Dipankar Datta has gone on to the extent of saying that while the petitions of such nature comes to the Supreme Court of India, it has to be ensured that it is not an old wine in the new bottle. There has to be, he has gone on record to say this, that it has to be a reason, there has to be a public danger which has to exist in order to ensure that VVPATs are recounted or are done to 100% verification. So he says, till then, if a matter of such nature comes before the Supreme Court of India, henceforth the Supreme Court of India should dismiss such applications in limine. Therefore, they have, because the matter needs to be closed somewhere. If an instrument has been in use for over 4.5 decades, and we must understand as an ordinary citizen that have we not seen the distinct election results which have come in these 45 years? For 10 years it was one government, for another 10 years it has been a different government. Prior to that it was a coalition government. Prior to that there was another form of government. Prior to that it was a Congress-led coalition government, etc. If we go back for 40 years, 45 years of the legal history of the EVMs, then we will be able to see that every such time the EVM has come out with a different electoral mandate, which is a proof, which is a testimony of the fact that the machines are working the way they are expected to. So there is no reason to doubt the functionality of that particular instrument. One thing which I would like the viewers to ponder upon more is that there is no way it can be connected to internet. Even the presidential elections of Donald Trump were put to challenge when this was done, but when he lost the elections in 2020, he challenged the electoral system right up till Supreme Court of India, Supreme Court of United States, and he failed. He could not win the elections because he had lost it. So we have to trust the Election Commission of India, which is discharging this constitutional function for more than 45 years with this particular apparatus. And the court in the ending paragraphs has beautifully, in the paragraph 35, Justice Dipankar Datta therefore observes, the issue at hand of doubting the efficacy of EVMs has been previously raised before this court, and it is imperative that such issue is concluded definitively now. So he has been very emphatic that this has to stop.
Yes.
Someday the doubting on the EVMs has to stop unless there is a substantial danger to the public interest. So the court of law has guaranteed the protection unless there is one reported. So what else can be done to maintain the free and fair elections, which is a part of basic structure of the constitution? Thank you.
So while the court dismissed the petition of returning to the paper ballots, it did issue two forward-looking directions to bolster the public confidence. Can you detail the new safeguards introduced regarding the symbol SLUs and the post-election verification of microcontrollers?
Now, this issue of SLU has been dealt by Justice Sanjeev Khanna extensively in paragraph 1 to 77. Now, when the Election Commission of India is handed over with the EVM, as discussed, there are three components just for the extent of repetition and clarity: control unit, ballot unit, and the VVPAT trail. They are empty. Once the election is about to happen, 10 to 15 days prior to that, what happens is these symbol loading units are brought into action. Please appreciate, I would like the viewers to emphatically understand this, that till this particular point of time, there is no allocation of which EVM is going to which polling booth or which constituency. There is no allocation. So what they do is, there is a laptop which is attached, and there is a firmware bit chip which is introduced into the VVPAT trail, and once you have, it's a burnt microchip which is being used, so that once you have casted the vote, it is over. You cannot reflash the same data. So if you will try and press the ballot button again and again, you are not going to vote. People may assume that by pressing 3-4 times, I will cast 3-4 times. It's not the way it works. It will burn the data. Now, there is a technical component to this particular setup. So, when I am going inside the election room, when I am standing in front of the ballot unit is going to transfer the data that I have casted the vote to the control unit. This control unit only knows the tally of the total number of people who have voted so far. It does not depict that who is leading or who has won. This particular exercise, there is a tab, there is a button which is written as result. That cannot be pressed at the time when the polling is going on. The EVM which is handed over to the Election Commission of India, when it is done after FLC, SLC and third level check of demonstration, it is covered with a pink slip. Once that pink slip is there, nobody can open it. After the election is over, that is again sealed with the signature of the polling officer who is present, and the polling agents, if they wish to, they can also sign. So once the unit is closed, the EVM is a combination of three components. It is not just one thing, it is a combination of three things. So this setup is taken by the polling officer, presiding police officer, to the district electoral officer's office. Therein it is opened in the presence of senior electoral officers and the representatives of political parties or the candidates themselves. It is not opened in isolation. So they are physically there. It is opened in their presence, that what has been voted upon is counted upon. And after that, what happens is, it's very interesting. That's why I say that viewers should read it. The Supreme Court of India has referred to Form 17C also. So there is one job when I have gone inside as a voter. Second is me as a presiding officer. I will also submit a report that contains serial number, the name, the list of the voters, the persons who have voted. So the total list of voters has to match three data: the total number of the total number of voters minus the persons who have refused to vote minus the persons who have been not allowed to vote. There is a different rule, which has rule 49M, which has been referred of the RP Act, to ensure that if people are refusing or they are not obeying the instructions of the electoral presiding officer, then they can be rejected, their names can be removed. So there are three things to counter confirm. The total number of voters will be tallied by the people who have voted minus who have been rejected minus the persons who have refused to vote. And all this counting is done when that pink slip is removed in the district electoral office in the presence of the electoral officers, polling officers, representatives of the political parties. In their physical presence, all of this is done. And how does this particular machine works? This particular machine is agnostic. It is not concerned with who is winning or who is losing. There is one tab in it which says result.
Yes.
So in that particular ballot, it will show, if you have pressed the button result, it will show that who has or which political party has got the highest number of votes.
Okay.
So it does not know who has voted for whom. It just tells you that who has got the highest number of votes. That's all. That's all. So the combination of the entire EVMs of the control unit of the EVMs, the result is being declared. So we understand that the technical nitty-gritties and details with which the Election Commission of India has worked upon to ensure free and fair elections is worth appreciation. And incremental suggestions, as I have already highlighted, that they want that the Supreme Court of India has gone on to the extent of saying that 5 EVMs per polling station has to be randomly selected for further scrutiny. So they have increased the level of efficacy by 4 times, right? 1 vis-a-vis 5 now. So they have increased it 400 times if we have to fulfill in that particular way. And they have also suggested a barcoding of the same. I think this would make the Indian election system as one of the most robust, reliable, strong method of electing the leaders to the lawmaking agency of the country. This is something which is commendable in terms of efforts by the Election Commission of India. Only thing which is to be done with great caution is that the persons who are voting are the actual voters. In order to ensure that there is full accountability of the elections which are happening, because that has now been in the debate.
Yeah.
So the level of accuracy with which the Election Commission of India is trying to conduct has been beautifully praised by the ending paragraphs of 35 to 38, and I would like to conclude by the remarks of Justice Dipankar Datta himself, and he writes, "I conclude with the hope and trust that the system in vogue shall not fail the electorate, and the mandate of the voting public shall be truly reflected in the votes cast and counted." So the Supreme Court of India has trusted upon the functionality of the Election Commission of India and has extensively looked into the allegations. It has not been that they have just randomly believed the words of Election Commission of India. No, they have extensively seen the way in which they are functioning. If you look into the paragraphs 25 onwards of the judgment of Justice Dipankar Datta, we would find that he has made reference to the different judgments of the Supreme Court of India on the said subject matter, wherein the same issue has been brought again and again and again before the court of law to doubt the veracity of EVMs. But he has beautifully summarized it in the closing remarks of the judgment, that we need to trust the way our institutions are functioning, and it's a very, very crucial judgment which every citizen of India, not just the law students, lawyers or academicians, or practicing lawyers should be reading it. It is something which is of great importance to any ordinary citizen who has the right to elect the electorate. So, with these words, I would conclude. Thank you very much.
Thank you so much, sir, for providing such insightful answers to the questions that I put forth. And I would like to thank you for coming over here today to participate in the celebration of Constitutional Week. So, thank you very much, sir.
Thank you, Vishesh, for inviting me and giving me the opportunity to speak.
Thank you.
Thank you.